Well, good evening and welcome to tonight's Expats Portugal webinar. We are looking at buying property here in Portugal, the legal insights and expert advice from Reis Pelicano. Some of the subjects we'll be looking at include the price, of course, the all-important price. Is it negotiable? When and how to appoint a lawyer, and you'll be talking to a top lawyer, or she'll be talking to us, and you'll have a chance to ask her questions as well. Surveys, are they useful, and when? Documentary, due diligence and its importance, the promissory agreement, the deposit and down payments, all of these very important when you're buying a home in Portugal. Change of rules after the CPCV is signed. You'll find out what a CPCV is tonight and what you can do about that, and how the closing and completion processes work here in Portugal. And to talk to you about that is Karina from Reis Pelicano. Good evening to you, Karina. Tudo bem?
Tudo bem, boa tarde, como está? Obrigada pelas introduções. Thank you so much for this introduction and for your words. You are always so exciting in when you speak, and so I'm glad to be here today. The invitation made by my colleague Daniel already here to speak with you and to be with you and try to bring you some information about the property purchase in Portugal, and of course he's here understanding the process and well, it's phases and it's steps.
Fantastic.
I also want to apologize in advance for some condition in my voice or any small interruptions that might occur to an eventual persistent cough, because
Oh, okay.
I'm still recovering from a cold, but I hope that it will not prevent me from explaining and from being in good condition.
Well,
Here
Karina,
I
if you
will.
need to pause, if you need to stop and have a sip of water, please do so. Okay, so let's take this nice and
Okay,
steady.
okay.
And I'm hoping you're fully recovered soon.
Yeah. I will drink a lot of water and
Good.
try not to cough so much. But I'm sorry in advance
Well, it's
for
very
it.
good of you
Okay.
to be here. Thank you very much indeed.
Okay. So my job here today will be making this can be a very extensive explanation, extensive information, but my job here today is make a small presentation related with a topic that you have seen on the screen, related with buying property in Portugal, understanding the process, and I will share some small slides and some small notes and keywords related with the property purchase process. And I will do my best to avoid the legalese speech, and
Thank you.
because I'm speaking to people
Lay
that
people. Yeah, to muggles. You're talking to
exactly
muggles tonight, yeah.
maybe some of you have dealt already with lawyers and everything. And I know we are not the most loved persons, but I will try to make my speech as clear as possible. With a first approach of what we understand, of what we think there are the two main steps of this process, okay, in Portugal. Then I will deliver just a more summary of what I will discuss.
Sure.
Then I will develop a little bit more each of the steps, one being the promissory agreement, and then moving to step two, that is the closing, the deed, okay? That is related with the transfer of the ownership from the property in Portugal. This path will end with from our side with some conclusions about these topics, and that we think are useful for you to retain. Like already explained, we would kindly ask you to write down the questions that you might have related with the presentation made. And at the end, we will open the discussion, and I will give the word to my also my dear colleague here, Andrea, that will answer the questions. Of course, I will be available to answer as well. But since we are both here, we decided to make this type of division of the presentation so that this can be a little bit more dynamic, and we can hear everyone. Okay, so let's move to the basics and to what we bring here today, and what is your main thought about this? So I, a foreigner, or even someone that already lives in Portugal, found a property that I like, and I want to know how this works now. Maybe you have made some visits, and on the listing in the real estate agencies, you've seen the asking price, and you want to make an offer about this property. That, well, the first question that may come to your mind is, how can I do it? Can I negotiate the price? What can I put on the offer? How can I make it? So these are the main questions that I believe come to your mind when this first approach of buying a property in Portugal. And I must reply that yes, you can. You can negotiate price, you can negotiate conditions, because you are in a negotiation process. So that's the first step. And yes, you can. And the asking price, but the main situation that I wanted to explain here is that, because this is something that some clients ask me frequently, is that what is the asking price? Can I offer another one? What is this? The asking price, of course, has, from my opinion, the main purpose, let people know which is the maximum price, more or less, that the sellers might want for that property, or might worth, because something is what you want, and another thing is what can work, okay, for the property. And it can have also, and necessarily have in mind, the location, the areas, and the conservation state of the property, okay? I want to say that sometimes, and it's not usual, to have offers made above the asking price. That's why I've mentioned that the asking price that appears in the listing of a property is usually, in general speaking, the maximum price that the seller wants for a property, having in mind a survey that he made, having in mind also other properties on the surroundings. Sometimes there are offers made above the asking price, but they are the exception, okay? So the price is always negotiable. The maximum and minimum of the negotiations, it's complete, can vary from situation. But my main purpose here is, as a lawyer, is giving you a glimpse about what are the things that you must bear in mind when presenting an offer. Okay, first, the price that you want and the disclosure of payments, or the schedule of the payments. Okay, it's something important to be included from the beginning in the offer that you made. The schedule of the promissory agreements, and for the promissory agreement signing, and for the closing. and the due diligence and the surveys necessary for a binding offer. Not this first offer, but what we call a binding offer is signing a promissory agreement. Okay. And I must say that this offer, that what I need to, that is not a binding situation, it's just informing that you wish to buy that property by a certain price, is usually done through the real estate agency that has the listing of this property. You might also have the help of of um, of someone that is narrowing the situations or the properties for you, and you can have yourself. But usually in Portugal, here the real estate agencies are connected or related with the sellers. So you make the offer before the real estate agency with the listing of the property that has a contract with the seller. Okay. Um, usually you can do this through the real estate agency that has a listing of the property. Nevertheless, from our experience, it's advisable to contact your own independent legal advisor, lawyer, so to speak, from the moment you narrow the options after the business. Because, of course, you sometimes you have 2 or 3 properties that you like, and maybe you will try to make different offers for each of these properties. And it's very important to establish from the beginning, not being binded by it. That's one of the main situations related with the offer. These three things, these 3 aspects, because it also can be the difference. It has difference for the promissory agreements. Okay, so this is what I wanted to say, and I also refer from the start this related with contacting from the moment you decide to make an offer for a property, because most of the times when you approach these real estate companies with the listing of the property, they also offer their services to take care of the paperwork and agreements for both of the parties, seller and buyer. We seriously are against having a same lawyer, legal advisor, processal, procedure manager dealing with both parties in this process. Okay, not only because, like I've mentioned before, the seller has a contract with this real estate company, not with the prospective buyers. So despite not doubting the seriousness of the majority of the realtors that work in Portugal, they are serious. But from our point of view as lawyers, as legal advisors, we think that they're they are a little bit compromised in the success of this deal, namely because they will receive a commission, and they might not be as independent as possible, and will be conditioned by the company with whom they have the contract with, and the seller with whom they have the contract with. Okay, so for us, and being a lawyer, of course I'm not also exempt, but I think it's always to separate the waters.
Yeah.
And have a legal advisor for the buyer and a legal advisor for the seller, because there are a lot of clauses to be discussed, situations to be discussed, that if it's the same person that is dealing with both parties, you already know what can happen. Okay,
Well, it does
so
happen, doesn't it? You have real estate agents saying, "Don't worry, we can take care of that." And I think in a foreign country, in a new situation, people do think, "Oh, that's a relief." But really, I think that's a key takeaway tonight is keep it separate.
as the majority of the time, it's not always like this, but in the majority of the time that I've seen this and that we have dealt with it, is oh, so fine.
Yes.
It's going to be everything is going to be simple and smooth and no
Yeah.
problem whatsoever. The documents are okay. We have everything in order,
Yes.
and they pressure you to sign something quickly, you
Yeah.
know. Well, we have here a standard contract. It was already pre-validated by our legal team, and they pressure you to conclude something quite quickly. And of course, I will disclose a little bit. Of course, there are standard rules that all the agreements have, but uh, you are a foreigner. You don't know the specificities. You don't know the situation. You look at the documents; they are all in Portuguese. You don't know if everything is okay or not. And there are there's there's not always um, and here the protection is of the seller. And
Yes.
my perspective here is from the buyer. I believe that's the majority of the cases here buying properties in Portugal. So that's what, from my point of view, and it's 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 from the all people would say the same. Have independent legal advisors from the seller side and from the buyer side, whichever position is. It's also important because we have another perspective, and we are not conditioned, like I said, by at least by anything. The conditioning will be the interests of the party that we represent,
Yep.
nothing more than that. So
Totally understand. Thanks for your question, Paul. Already we're getting some questions coming in, and we'll give Karina a chance to deliver the presentation, and then we'll come back to all the questions, and I'll gather them together as best I can. And don't forget, you'll have a chance to chat personally with Karina after the recording is concluded as well. So sorry, Karina, back to you.
okay, okay. I will see that we have a lot of questions, but we will try to reply to all at the end. Okay. So just this is one of the ideas and one of the topics that we had here to discuss is what the timing for contacting the lawyer. So the timing, I believe, will be as soon as you want to make an offer, at least to discuss ideas and to discuss where to go, how to explain, how to set up the offer, and to have already some ideas. I'm not saying about discussing the commercial side or if that house, well, we all have our opinions, of course, but not discussing the commercial side, if this house, if the price of the house is the accurate one, is the best one or not, because in that case, yes, real estate agents know more the area and the market, but to discuss more or less the interests and your needs. I think to have a legal independent opinion will be important in that stage. Just to give you a glimpse, to give you ideas, to exchange some notice. Okay. So the next situation. Imagine you have presented an offer, and that offer or counter offer, negotiations between the parties related with the price of the property and the conditions. Okay, scheduling of the payments, deadline for the closing, and surveys, like I've mentioned. What's next? I Can a person, after making an offer, change the price, change the conditions? Is this offer binding or not? I must say here a moral point of view and a legal point of view. It's yes and no at the same time. I will explain. When you make an offer and it's accepted by the seller, okay, it's expected that the binding agreement, the promissory agreement, that's the first step that I mentioned here, to be signed by the party, reflects the conditions and the offer presented. Okay, so I would say yes, you are morally, but morally is just a principle of understanding. Okay, so I would say yes, you would need to stick with these conditions. Okay. However, most of the times when this offer is made and is accepted by the seller, there were no legal documents presented of the property, or even if they were shown, you might not understand anything that was stated in there. So the potential buyer is not fully and actually aware of the legal situation of the property, areas of the property, owners, if the licensing is in order or not, if there are situations related with the configuration of the property that need to be updated or changed. And so my main conclusion is that of course you are not binded. It's not a binding document that you need to follow the conditions presented in the offer. Okay, so that's why, and following a little bit more and giving you a little bit more of information, here assumes importance. And I need to make a small note here. And basically, sometimes even this is the first and actual necessary intervention of the lawyer, is the legal due diligence, okay, of the property. And what is this? What is this? It's an analysis of the legal documents of the property that us lawyers ask for, or to the seller, or to the real estate company, okay, in which we will look carefully and thoroughly to these documents and produce a report about any concerns or urgencies about the property, okay? Namely, we will see if the areas in the documents of the property are coincident, if the owners in the documents coincide, or if the person or the company that is shown as being the seller is not in fact the seller. So we need to have some more additional information, or be more careful about the information that we have. Ongoing licensing or lack of licensing, or constructions not completely licensed, or if you are buying a plot of land and you are willing to build a house, this can have different situations regarding the licensing, okay? And if the property has mortgages or any encumbrances that needs our attention and need to be specified, included something about it in the promissory agreement. Okay? Also, it's convenient in this stage, mostly if you are interested in buying old buildings. And when I say old buildings, I would say 15, 20 years old, okay, or more, to have perhaps a structural survey completed by a specialized technician, an architect or engineer. Why only these cases, this structural survey, not the due diligence, not the documents? For me, that's always mandatory prior to signing a promissory agreement. That is the first major step, okay? Why only in these cases the survey from a technical inspection to the property? Because not only because in Portugal that is something that is not yet quite broadly used in our country, and some sellers are still not very comfortable with this because they think that people are just are not trusting the documents, are not trusting in them. We have this Portuguese way of seeing a lot of face to face, a lot of, and some types of sellers might not be comfortable, and also might refrain from moving forward with any agreement. Okay, it's just some. I'm just giving you some ideas that we have experienced with other situations. But what is the main reason for this structural survey only from our point of view being necessary for buildings with these ages? Also because more recent buildings up to 10 years of their constructions, they have a warranty related with the period of construction. For structural defects, we have a warranty of 10 years from the end of the construction of a warranty. So if any problem arises from the construction within a period of 10 years for structural situations, we have a legal warranty into force. Okay, that's why the first situation that. And also, it's an assumption, okay? It's expected a licensing to exist. Because generally speaking, buildings that were built prior 1951 don't have any licensing. Buildings after 1951, presumably they have licensing. It will depend of the municipality, but this is just the general idea. And we assume that having recent buildings, that no major changes were made in the apartment property building. Also, from 2004 onwards, it's mandatory for all the buildings to have what we call the identity card of the property. That is more specifically called the technical sheet of the property, that has, generally speaking, all the information about the materials and how the construction was made, the plumbing network, the electricity networks, so we can have more or less all the information related with the property. And so that's why, of course, it's advisable and also, namely, when we are, sorry, just a little bit of water.
Oh, you carry on.
And namely, when we are talking about used properties, apartments, houses. So you are buying from another person, not a new house, but a house that someone is living there or has lived in there for a while. To have an inspection or visit with carefully, take some pictures, make some videos to see how the conservation state of the building is, but not what we call a structural survey. That and because it's more costly, we would advise to be performed mostly to these specific cases, okay? And that's why we have just mentioned this situations has been the ones that we advise these types of surveys to be made. But having in mind the surveys and the due diligence, and because this is very important, for you to be sure about what you are buying, and also to negotiate the clauses that will be included in the promissory agreement. That is actually the first binding document within between the parties. That's why, in our opinion, we consider that the moment that these researches, the surveys, should be made is prior signing the promissory agreement. Okay, because like I've said, they would, from my point of view, they will lead to a fully informed decision about moving forward with the binding agreement, or the need to make adjustments to the conditions initially presented. That's why I've mentioned that, okay, I've made an offer for a certain price, but afterwards, when looking at the documents, we detect a lot of problems, or when performing the surveys, we detect a lot of problems that we have not seen when we were there, and our offer was based on certain conditions that specifically were not met. And this is the moment to negotiate even the price of the property from my point of view. Okay. And also, just a brief note to state that if the normal conditions of the promissory agreement are not yet met, that is, I'm repeating myself, but I need to say this is the binding document between the parties. Until you sign a promissory agreement, you can negotiate everything. You can withdraw your offer. That's why I've spoke about moral behavior related with the offer made. But in fact, until you sign a promissory agreement, you can negotiate, you can withdraw, you can ask whatever you think it fits for you to make your decision. And for instance, if there's some conditions that are not yet met, for instance, documents that are not updated, that do not exist, the licensing is pending, or doubts arise from the due diligence performed, division or unification of plots, if you are buying a plot of land for constructions, for instance, pending registrations, construction projects not yet approved by the municipality. Basically, and just a small notes to say that maybe prior to this first legal binding agreement between the parties, the promissory agreement, it could be advisable to have a first document signed called reservation agreement. Okay. And what is this? What is this? This is reservation agreement. Is the reservation agreement is destined to secure the priority within a certain period of time of the prospective buyer in the negotiations with the seller, okay, and the relatives, of course, preventing other offers to be accepted or being negotiated simultaneously. I must say we are not in love by this document whatsoever, because if because we like to, if the conditions are met, to have the seller binded to selling you a property, and you of course buying the property. But the reservation agreement is not, it's a legal document, of course, it has legal existence, but it has not a legal specific framework. So it's always a discussion, will be it's binding or not, should the relative be involved or not, and namely in the situations in which the realtors have not the exclusivity in the listing of the property, because the reservation concluded with the seller will bind the realtors. If we have several realtors, we should conclude the reservation with all, for this to be perfectly freezed in the market. And so that's why we're not in love by the reservation agreement, because it has some aspects that might lead to different interpretations, and that's not why we are in love. But we acknowledge that it's a useful document for securing the property while, for instance, the due diligence is not completed, or the surveys need to be performed. So, like I've said, the surveys, due diligence that will be performed by a lawyer, okay? Analysis of legal documents of the property, and the structural surveys that usually is done by a technician, engineer, architect, related to the technical security, technical situation of the property. We think, and it's advisable from our side, to be made prior the signing of the promissory agreement. And why? Because we need to secure that all the rules that will bind the parties will be established in the promissory agreement, so that it can be as stable and as possible, if desired, of course, and for the closing to go seamlessly. Okay, this does not mean that the promissory agreement needs to remain unaltered, or that some changes are needed to be included in this document. But the problem here, not being exactly a problem, is that if being this document signed by two parties, any change to this agreement needs to be also agreed by both parties. And so if we have all defined, or the major situations defined from the beginning, and some specific situations that need to be established, namely regarding repairs to be made by the seller, licensings that need to be taken care of, because it can also have influence in the date for the closing, updates in the areas of the apartments or the property that need to be taken care of. So all the situations can be solved until the deeds. The promissory agreement is the best moment to gather all these rules and all these informations. Okay, so I think it's important that the rules applicable to both parties uh, can be from the start the to more uh, adapted to the real needs of the parties. Okay, like I was saying in the introductions here in this today, is that because the first tendency will be to quickly conclude a simple agreement, because the reality seems to be simple, but increasingly this area, the real estate area, in our experience, and due to the changes in the regulations, namely the ones that enter into force in the beginning of this year, specifically for those who are buying properties under constructions or um, or other properties. It can be important to have this service made before the promissory agreement, and including specific rules related with the concerns in the promissory agreement. May I recall you that currently is we are exempt of the exhibition of the licenses of usage and the technical sheet of the property in a deed. Okay, so it's very, from our point of view, important to have this service and due diligence made prior the signing of the promissory agreement, because we can detect eventually problems with the licensing or inexistence of that license, that from the point of view who is buying a property can bring you a lot of problems in the future. So sometimes being easy in the beginning and quick in the beginning and signing an agreement with just a bunch of clauses and the silent ones can be very tempting. But the agreements are made for the situations when there are problems, and not when people are getting along well and everything is going smooth. Okay.
Yeah.
So that's why we think that the stage in which the service and the due diligence must be made are prior the signing of the promissory agreement. Promissory agreement. Being a little bit more specific about, and having mentioned here standard clauses, specific clauses, what are the clauses, and of course there is negotiation side of this. It's an agreement, like I said. But of course, there are standard clauses included in the promissory agreements. Okay. The first of which being the price and the respective home in terms of payment. Okay, as a rule, and one of the questions that I've just seen by the corner of my eye here is usually when upon signing a promissory agreement, there's a definition of a down payment. Okay. Usually when signing a promissory agreement, the buyer will need to hand over to pay a deposit, or better stated, a down payment, which the standard is something between 10% to 20% of the price established for the property purchase between the parties. Okay. This down payment usually is made, like I said, upon signing of the promissory agreement. Does not need to be made exactly on the same moment. Usually, and also standard, that this payment is made by bank transfer, and usually it's stated that the transfer will need to be executed or credited in the seller's account within 3-5 working days, having in mind the procedures of each of the banks. Okay. Sorry.
Yeah, you okay?
And I must also say that this transfer, the bank transfer, can be made from any account. Okay, does not need to be made from a Portuguese account. I would say that it's advisable for the buyer to have a Portuguese bank account, mainly because it will ease the procedures and the transfers to be made, but that does not need necessarily to be made from a Portuguese bank account. But the thing that we recommend is that the transfer is made to the seller's account. And what I'm referring this because I've seen in several situations requests of the realtors, mostly the realtors, for the transfers to be made to the realtors, the transfer of the down payment to be made to the realtor's account, the company of the realtor's company. We strongly don't advise this, and we are strongly against it. Okay? Not only because in the future, for money laundering purposes, you need to prove from where the amounts came from to where they were deposited. And it's important that everything coincides, seller and buyer, not having any third entities in between.
Mm-hmm.
And also because, from our point of view, the realtor is not a part of the promissory agreement. The promissory agreement is concluded between the seller and the buyer. Okay? And so this can lead, imagining, and I will give you also another information, is that this all can be made at a distance. The seller can be represented by a lawyer or by a third party, and the buyer can be represented also by a lawyer or by a third party. From the buyer's side, the situation for any future implications related with breach of contract, for instance, or related with actual collection of the amount. It's quite different to have the amounts an account that belongs to the seller than rather than an account that belongs to a real estate agency. The risk here is, in the worst case scenario, and if all this is made at a distance, namely the seller being represented by a third party, that the seller at the end might say that she, the company, did not receive a portion of the amounts in this in their account. So we are strongly against this request. We have seen it a lot, and but from my point of view, we don't advise this request to be followed, because in an analysis of that request, I believe the main goal is collecting in advance from the realtor side, okay? Collecting in advance their commission. And the commission should be paid when the closing is made. And it's something between the realtor and the seller. The buyer is not a party, like I've mentioned in the beginning. It's not a part of this commercial relationship. So I would advise to the bank transfers being made to a seller, to a seller's account. Usually we ask the proof of the account to see who is the owner or the of that account, to be sure that this compliance is made. But just to give you a note that sometimes these types of situations occur. Okay. The remainder of the price, usually in the promissory agreement. So we have this down payment paid upon signing of this agreement, and the remainder of the price paid at the day of the closing, at the day of the signing of the deed. Of course, we have situations in which this is not actually as this. I need to refer the situations about houses that are under construction, that usually you can have a new deposit made between the first down payment and the final closing, usually related with the accomplishment of milestones or some parts of the works that were performed, subject, of course, to a report and to effective information that that milestone was achieved. But basically, and the standard is between 10 to 20% of the purchase price as a down payment upon signing the promissory agreement, and the remainder paid with the signing of the deed. And here, just also to inform that usually this payment is made by a banking check. Okay, this banking check. That's why I was advising you to have a Portuguese bank account. Should because of banking compliances and procedures, should be issued from a Portuguese bank account. That's why it's advisable for you, at least for the closing, having a Portuguese bank account. But if you don't want to have for in a near future a bank account, don't worry, because the majority of the law firms, ours being one of those, usually have some client's account sort of escrow account in which we are able to receive deposits from the clients, and we will manage the issuance of the check for payments to be made. Okay. We don't advise
Bless you, Karina.
the payments in the closing to be made
Yeah.
by bank transfers because usually the sellers don't want it. It's not very usual to have it like this, and because they need to declare, and because sometimes some problems with the deed and the closing can happen, and the deed is not made on the aimed date or in the aimed hour scheduled for that purpose, and you already executed a transfer, so you cannot have more than 24 hours. You don't get have the money back, and so with the banker's check on your hand, if the deed is concluded, you hand over the check. If it's not concluded, if it's needed to be postponed for any circumstances, you'll keep the check and deliver it when on the new date, and no questions about it. Okay, that's why you use broadly the banker's check for the closing. The other standard clause in the promissory agreement is the scheduling of the closing, the conclusion of the deed of transfer of the ownership of the property. And I must say that there's no, regarding the specific deadline, there are no rules. They are basically the needs of seller and buyer. For instance, the buyer needs to move to Portugal in a certain date. It has a lease agreement that is going to terminate in a certain date. So the deed needs to be done, and the transfer of the ownership needs to be done in a certain date, or the definition of a date having in mind licensing problems or other situations. But altogether, we can say that the standard timings for this are between 30 to 90 days between the signing of the promissory agreements and the signing of the deeds for the closing. Just a special information related with deadlines for the closing. If a buyer is considering getting a loan for this purchase, okay, this can have influence in the closing dates. In these cases, we recommend the closing date between signing the promissory agreement and the actual date of the deeds, 90 days. And why so? Because of the procedures related with the loan before the bank. Okay, usually they take time. They need to make a evaluation of the property. They need to comply with standard timings for the approvals and for the issuance of the approvals, and also for reflection times. So that's why we are mentioning that specifically when a loan is involved. We usually establish 60 to 90 days between the signing of the promissory agreement and the signing of the deed. Okay. Also, in the case of loans, just to have this additional information, we usually see, and you will see included or we as lawyers in this case include this type of clauses, which is also broadly accepted, is the possibility of termination of the promissory agreement in case the loan is denied or the evaluation of performed by the bank does not reach the needed amount from the loan. In these cases, when we are talking about, and the clients, the buyers, are willing to obtain or are in the procedures of obtaining a loan, to have include this clause, because what will be the consequence? In those cases, the buyers will receive the amounts handed over as deposits back. Okay, that's why one of the clauses that usually, when we are talking about the loans, we include in our standard agreements. The other clauses that also are standard in the promissory agreements are the ones related with preemption right. And what is the preemption right? In Portugal, the municipality, each municipality, and the state, through the State General Directorate of Heritage, have a legal preemption rights related with any property purchase. Okay, each municipality has a preemption rights for the properties located in the municipality area. Okay, so Lisbon for properties located in Lisbon, Porto for properties located in Porto, and so on. And the seller needs to file a request in an online portal called Casa Pronta, and these entities, state, municipality, have 10 working days to exercise these legal rights and say, I want to buy this property instead of the promissory buyer. I've never seen this happen unless you are buying the Mosteiro dos Jerónimos or Clérigos. Okay, usually related with the national monuments or to protection of national monuments or something like that. We never seen this happen, but we need to specify this on the promissory agreements, because if this happens, if they exercise this preemption right, the promissory agreement will be also automatically terminated, and the promissory buyer is entitled to receive the amounts paid as a down payment deposit back. Okay, in one lump, in this case, not in double. Also to mention that the preemption right also exists if you are buying a plot of land from the adjoining owners. Okay, this has more details, but bear in mind that if you are buying a plot of land, rural, strictly rural, so no urban, just land, and if you have neighbors that have also other plots of land, they also have a preemption right that needs to be taken care of by the seller. Okay, this is the responsibility of the seller. They need to inform them to exercise this preemption right. And also another situation of preemption, of legal preemption right, if you are buying a rented property, meaning you are buying a property for investment purposes, and you already have a tenant there. The tenants with a lease agreement with at least 2 years of duration also have a preemption right in the acquisition of a property that is being prospectively sold.
Karina, I'm sorry to interrupt. I'm just getting a little anxious. We're running out of time, and we're not going to get to the questions. Would it be okay to hold it there?
Yeah,
Thank you.
I will. Sorry, I talk too much because I want to explain everything,
I know. There's so much to cover.
So
yeah.
The other standard clauses, just to make a briefing: breach of contract, and the consequences of breach of contract. This is mandatory. It's one of the few situations that the civil code determines for the promissory agreements. If from the buyer side, the seller is entitled to keep the amounts received from the seller side, if the breach of contract is from the seller side, the buyer will be entitled to receive the amount in double. Okay. And alternatively, both of the non-defaulted party can go to court and obtain a statement in which the court will state that the deed will be concluded on behalf of the default party. Okay, it's called the specific execution of the promissory agreement. So that's why. The other standard clause, and for me this is important to say, because if one of the situations that we have a lot of clients asking us this is the formalities. Always, when possible, always acknowledgements of signatures of a promissory agreement. Sometimes people ask if this can be signed just digitally through DocuSign, we just exchange a digital version. From our point of view, signing in person, and in person means not the promissory buyer, but someone on his behalf, but with the acknowledgement of signatures. And because also this is a probationary formality that is established in the civil code for the promissory agreements, and is the only safety that the promissory buyer has regarding the formalities of the agreement, because the seller receives the down payment, which is the guarantee from the promissory buyer, to have acknowledgements of signatures of the promissory seller, so that he cannot state in any time that I'm not binded by this agreement. It was not I that signed this agreement. So from my point of view, very important, and because it's daily receive these requests and acknowledgements of signatures. All of this can be made in person. The promissory buyer and the promissory seller can meet up and sign in person, or can be made through a power of attorney, being both represented by a lawyer or any third party that they wish. Okay, this is more or less that's what I needed to speak about the promissory agreement. If everything goes according with the plan, the second situation will be, there's a small typo here. The second situation will be the closing. Okay. Once again, represented by a lawyer. The payment of the remainder of the price I've already mentioned to you, made by a banker's check. And in the closing, there are another important situations to be referred. The payment of the taxes. There are two taxes that are mandatory to be paid upon signing the deed, is stamp duty, transfer tax. Stamp duty is always the same, 0.8% of the purchase price. The transfer tax will depend on the purchase price and the destiny or destination of the property. If it's for your own housing, secondary housing, and or other purposes. Okay, there's a scale. I can. The time is short, but if you want, we can give you more information about this. And these taxes usually no, they need to be paid by a Portuguese debit card. Okay, no banker's checks, no transfers are allowed from the tax authorities. So all paid by a Portuguese debit card. So once again, that's why I've made the notes that it's advisable to have a Portuguese bank account or perhaps using the client's account. And just to also note to state that the transfer of the ownership is not actually concluded with the deed. There are additional steps to be made so that we can say that the ownership is definitely transferred to the new owner. It's related with the registrations, okay? The registrations. After the deed, the notary will inform the land registry offices of the new owner that will need to update the land registry certificate so that the new owner is shown in that document, and that is the document that will be the important one for you to show as owner that that property is yours. Okay, the deed also, but like I usually say, no one needs to know how much you have paid for the property. They need to know that you are the owner. Okay, so this is the legal document for any entities, tax authorities, any other prospective buyers that you want to sell, everyone. The other document that needs to be updated is the tax department certificate. That's the two major documents of the property. This is just for tax purposes, but needs also to be updated for the new owner. And also, and this is additional information, for the closing to be actually concluded, there are two additional situations that needs to be taken care of. The utilities, electricity, water, and internet, other ones that you want to be put under your name, and also an insurance. Very important to have an insurance to your house, although not mandatory, but you'll be protected against a lot of risks. And if you are buying an apartment, you need to inform the condominium of the new ownership, because you will need to obtain information about the payment of the condominium fees to where they should be made. Okay, the closing is quite simple. It's just the information and the documents are mostly from the seller side. The seller must collect all the information, updated documents of the property that I've already mentioned here, to be presented on the deed. From the buyer side is usually the payment of the remainder of the price and paying the taxes. Okay, so basically making payments.
Okay,
related with the closing.
Karina, I wonder if I might ask if we can have the presentation in our forum, and the conclusions here can be a bit of like an aid memoir for people, because as Jerry said, they were running out of time, so it'll be very useful for people to have a chance to ask you some questions, if that's okay. So
okay,
we'll make sure we get the presentation, and of course this will be available on the YouTube channel as well. Thank you for a very thorough and in-depth look at buying a property here. You've got some great feedback here. Jose, this is an amazing presentation, so detailed and rich. Thank you. Karina is great from Alex. Frank, we probably will need a continuation of this webinar, part 2, to cover all important subjects. And this is perhaps the best webinar you've put on. Well done. Very informative. Really great in-depth webinar. And a few other comments there from Jose and Anna. So thank you very much, Karina, for the time being. We've only got a few minutes left until we have our Dream Team session at 9. And I know your colleague, Andrea, will be with us for that. So she can pick up the baton and run with it with any other questions. But for the time being, thank you. Let's take some questions, shall we? And give you a chance to have a breather.